Hi, everyone. Welcome to the Pelago agent topic on the seller financing form. This is for the Northwest MLS 22C, which is the seller financing form. There's a lot to this form, and we're excited to have a special guest with us today, Julie Martiniello. She is a lawyer with Dimension Law. I've been using Dimension Law personally since 2012. And I still do. When I have a random question, I reach out to Julie or her partners. So if you're looking for a lawyer, they're great real estate attorneys. They're local. I think they're in Tukwila, which is a great spot between Tacoma and Seattle. Maybe not a great spot, but very convenient location between the two. And we got a couple more people joining us, so we'll admit them in. And we're going to do a deep dive into this form. And before we dive in, I want to have Julie introduce herself, tell us a bit about her experience in real estate, her experience as a lawyer, and then we'll dive in. And if anyone has any questions along the way, just throw them in the chat.
Yeah, thanks, Gideon. I'm excited. This is the seller financing stuff can get kind of complicated, so I'm happy to be here. Like Gideon said, I'm a partner at Dimension Law Group. My business partner, Cynthia Melton, owns the other half of my firm. And we've been doing real estate law since 2013, 2012, 2013. And a large base of our clients are real estate investors. We do a lot of landlord-tenant law, contract drafting, reviews, and seller financing. We do this quite often for our clients in the investment realm where they're purchasing properties even off market sometimes, and they want to make sure that the contracts are right, or really importantly for the seller, that the contracts are right. So I'm happy to be here. And like Gideon said, if you have questions as we're going through, feel free to put them in the chat so I can address them. And if you have follow-up questions afterwards, I'll put my email in the chat if I don't know if it was already provided, and you can always reach out to me there.
Wonderful. So do you want to share your screen? I don't know if the workings work for you, or I've got the 22C pulled up on my end.
Yeah, I think I can share it on my end, but let's see if I
So while you're doing that, I'll kind of give you guys an overview of how I see this form used. So there's a lot to this form, but the most common way that I see this form used is when the seller basically doesn't have a mortgage. Like this form will allow you to do things like assumptions and wraps, but the basic construct that I see is the seller doesn't have a mortgage and they're going to sell it to the buyer with seller financing. And normally that's like something like a low interest rate, 2, 3, 4, 5% interest rate, amortized over 30 years, but it balloons after 3 or 5 years. So like the normal assumption here is the form will allow you to do like a 30-year mortgage, but like 99% of the time, sellers are saying, hey, we're going to give you this mortgage for like 2-3 years at a 30-year rate, but only for 2-3 years. And then you're going to be expected to refinance.
Yeah, that's the most common scenario, is exactly what you said. That the seller, and why would sellers do something like this? There's a couple reasons. One, they know that interest rates are really high right now. They want to get a better sale price, so they're willing to carry that loan at a lower interest rate for a few years. Another thing, if you're advising sellers, or you're advising a buyer that's trying to get a seller to do seller financing, is that it stretches out the capital gains tax that a seller might have on the sale of their home, because they're getting those payments over time instead of all at once. And like Gideon said, really the safest, most traditional process of doing seller financing is when the property is owned outright. There is not a current loan. We'll get to a part of the form that talks about things like assuming a seller's loan or doing seller wrap. And I always want to caution clients, because whenever we have an existing loan that's not going to be paid off, there are due on sale clauses, mortgage fraud, things that we want to get into, but we can kind of address that when we get later on down. Those aren't as common, so you may not have as many questions about that.
Wonderful.
Do you want me just to kind of go through section by section?
Yeah, I think that'd be great. And you know, this first paragraph is probably the one that I get the most questions on. And I honestly, like, I don't know how to answer it because it's like so many of our agents are buying rental properties, and it's like, does that count as residential, or is residential like owner occupant?
Yeah, no, that's a really good a good distinction. So this part of, section A, that's what we'll kind of talk about. Why do we even have this in here? There is a federal law, it's the Dodd-Frank Act is what they call it, that this is essentially trying to say, if you're going to be giving a loan to somebody, we need to make sure that we're in compliance with the federal law. And what does the federal law says? The federal law says that if you're going to be giving a loan to somebody for residential purposes, you can do 1 per year under these terms. You can also do 3 per year as a seller that has slightly more advanced requirements. So 1, generally, if you are purchasing a property that you are not using for your primary residence, or you're selling a property and you're providing funding that will not be a primary residence, these bigger restrictions don't apply, because you're purchasing it for what we call a business purpose. And so that is kind of the overarching distinction of, is this going to be a primary residence or is it not, right? So yes, a residential, the other portion of it is that, especially under Washington state, a lot of the rules and regulations don't apply for licensing, don't apply for loans that are taken for commercial purposes, right? Investment purposes, if it's raw land or if it's being used for agricultural purposes. And so it's, this section, it is limiting the seller. It's not limiting the buyer, if that makes sense. I don't know if that's clear.
Yeah. So
yeah.
So the risk here of will or will not is on the seller to get this right. But as a buyer, if we're buying a house that we're going to make a rental, would we check the will or the will not?
Will not.
Okay, so it's even though it's a residential property, if the buyer is not actually living in it, we're not considering it a residential dwelling.
Right. So what does the Dodd-Frank Act says? That if the loan is being used for a primary residence, a second home, a vacation home, so it's a loan secured by a property that the borrower will use for residential purposes. Now, if you are immediately going to be having it used as a rental property, then that's what we consider a business purpose, right? This form, it's interesting because the form uses language, but it's, as you said here, Gideon, it's not clarifying what's a residential property. But if you go to the federal law, to that Dodd-Frank Act, that's where it will tell you it's whether it's a business purpose or not is really what we're looking at. So in our firm, when we're doing kind of these off market and we're drafting the documents, we will have the borrower sign a certification that the property is being used as a business for business purposes and not as a residential property for themselves, so that that covers the seller from having to meet exempt, certain requirements, right? That being said, in general, if you're offering seller financing for a residential property, it is a good idea to have the loan be fair, right? Which is essentially what these terms are here, that the repayment schedule does not result in a negative amortization. What does that mean? Because that's kind of a question. Well, what's a negative amortization? This is if you are offering a loan and the payments that you're requiring are lower than the interest that's accruing, and then the interest is being added to the principal. And so the person ends up having a higher principal balance than what they originally started out with. So I think, kind of going back to what you're saying in the beginning, in most instances, we're having a pretty straightforward transaction. It's, I'm loaning you $300,000 and you're going to pay me back monthly, and this is the interest, this is the principal, and the loan's amortized over a 10, 20, 30-year period, whatever it may be. So anytime we start to get funky with payments being made, or no payments for the first 6 months, we just really need to be careful with how that's being allocated. If you're doing things how they're standard on those LPO forms, which we'll get into, this is not going to be an issue. This section 4. And then same with section 5. If you are doing, most people are not doing adjustable rate mortgages if they're just selling a home that they own. But you can. I would say 90% of the time we're doing just a fixed rate of interest, whether that's 5% or 7% or whatever it may be. I think most real estate agents are going to be familiar with what an adjustable rate mortgage is. And that's just where the rate is subject to change, usually go higher after a certain amount of time. Here, this is just saying if you're going to do an adjustable rate mortgage, it cannot adjust sooner than 5 years from when the loan starts. And it has to be reasonable. What does reasonable mean? It's probably better not to do anything. You're not going to go up to the usury rate, which right now is about 12%. Maybe it goes up to whatever the market rate may be in that 5-year period.
What's usury mean?
Yeah, so usury, and this goes down when we talk about, well, what's the interest rate going to be? And what's the default interest rate going to be? Usury is where you are not allowed to charge an obscene amount of interest. So if I loan you $100,000 and I'm charging 50% interest, usury is the limit that you are allowed to do a maximum interest rate. And that changes from time to time. It's typically 4% what the market rate, plus 4% what the then market rate interest is, or 12%, whichever is higher. Right now, I think it's at 12% either way, because I think the base market interest right now is about 8%. So that's just saying that you can't charge somebody 20% interest in this scenario.
Gotcha. But
Yeah.
does that relate at all to if it's going to be a residential dwelling or not? Because I know that hard money lenders have been charging 12% since rates were
Yeah.
down 4% and 3%. So
Yeah.
how does that work?
Yeah. So yeah, if something's for a business purpose, you can charge more. However, there's exceptions to when, but if it's a primary residence or a residential for the borrower, you cannot go above that usury rate. Yeah. And so there is that's why when we look at things like credit cards, they can charge, these crazy amounts of interest or payday loans. Or hard money loans can charge a little bit more, so long as you're not using it for a residence. Yeah. And so, if you are going to be selling to somebody that's going to use it as a residence, you as the seller cannot be an LLC or a corporation. It has to be, an estate, a natural person, or a trust, right? That's what the Dodd-Frank Act says. Again, we can only do, one of these per year generally as a seller. And you cannot, sometimes I have clients that are contractors or they're flippers, right? So you were not the contractor for the building the residence. Now, this is saying it's in the ordinary course of seller's business. If you're a homeowner and you remodel your kitchen, that's not going to apply here. This is essentially saying that if you're somebody who's in the business of fixing up or building homes and selling them, you can't offer seller financing.
Okay, that's huge for us to know.
Yeah, so that's a good distinction, because what they want is essentially like builders or flippers, that they can't do the seller financing. But again, if your clients remodeled their own bathroom or something, they don't do, or maybe they did build this house, but they don't, or did a full remodel on the house, but they don't regularly do that. That's not like their ordinary course of business. They can probably still fly under the federal exemptions. What I can do get into as a follow-up that you can email out is I can give you a list of the different rules, like the actual federal law that this is getting to.
Wow. Yeah. A lot. There's so much to unpack just on this one paragraph alone. This is going to be quite the master class.
Yeah. And I think it's, it doesn't really say it here, but it is important to note that what this is getting at is that federal law that was passed. And so when we have questions of, is this person allowed to do this? We want to go back and look and say, well, what does the federal law actually say? And that's what this section is encompassing. It's essentially copying over, what that Dodd-Frank Act is encompassing.
Awesome.
Yeah.
Yeah, I think we could keep going on that.
Perfect. Yeah.
The time we move on and see how much time we
yeah. So right here we're talking about the federal. Our next one is, okay, under Washington law, can you do this? Right. So Washington Department of Finance, that's the DFI waiver or exemption. They have that only, licensed mortgage brokers can provide loans in the state of Washington. However, there are exceptions, right? And I'm actually going to put in the chat the Department of Licensing's and that should go through there. If you look on the Department of Licensing website, it is very clear when you have to have a license, when you have an exemption, and when you may have to seek a waiver. And that is essentially what this paragraph is saying, is that, again, if this is used as a residential dwelling, so again, we're getting to, is this person's home, whether second home, vacation home, whatever they're going to be living in, they either have to get a waiver, the seller would have to get a waiver from the Department of Finance, which that website link I gave you at the bottom has the email and the form to request a waiver. Or you have to say, well, no, it's exempt. under the RCW, I don't have to have a license or a waiver. So what are those exemptions? Those exemptions are if you are lending to a immediate family member, you don't have to have a waiver. Or if you are lending to somebody that is not using the property for their primary residence. So you're lending to them for commercial, business, or agricultural purposes. Again, and you're not securing against their primary residence. So that's kind of the big thing. And what are all these rules for? We're looking back, we don't want people to lose their home. Right. That's kind of the overarching thing. We want to protect people in their primary residence. So again, this is one of those things where if you're saying, or if you're, and the other way you don't need a DFI exemption is if you are selling your primary residence. So if I'm selling my house that I live in, I don't have to get a waiver or exemption or licensing. And that is, you can see those specific exemptions on, it's RCW 3104224. And I can also put that in the chat. But those are saying you do not have to have licensing or an exemption. The ones that mostly apply are if you're going to an immediate family member, or if you are providing a loan on what was your current primary residence when you're selling it. And so I don't know if that's pretty clear there. But let me see if I can add that to the chat. Because I think I find, and maybe because I'm an attorney, when I see the underlying rule, things make more sense than just a paragraph and this big giant paragraph, right? So where do you need to get a waiver, right? You're going to need to get a waiver if the seller is selling not their primary residence to somebody that is not using the property for investment purposes. So if someone's buying the property as a primary residence or a second home, and the seller is not selling their primary residence that they're living in at the time of the sale, or that was when the sale's underway, then you have to go to the Department of Finance and ask for an exemption. And the process for that is there's a PDF that we fill out and you email it to the Department of Finance. So that website that I sent you, there's that whole license waiver steps. And then it's important to note, and you can see here on C, that even whether you have a waiver or not, or need a waiver or not, even if it's exempted, you still need to provide, the Department of Finance has like a disclosure PDF, whether there's a fixed rate or variable rate loan, and that does have to be provided to the borrower. And that is also on that department. And it might help to share that website. I don't know if people already have it up on their own screens or not.
We got the links in there. Maybe let's see if we got questions on that, and then we can dive in more. See if let's maybe we move on to like kind of get through some of these other paragraphs.
Yeah.
And visit some of these.
Yeah. And any questions, just throw them in the chat, or you can email me later. But the Department of Finance website that I sent, it's a really good kind of plain language explanation of when you need a waiver or when you're exempted, and if you're not, what you need to do. So go ahead, look there. And it has that disclosure here that we're talking about. Now, the way that this addendum is written is that is based on using the LPB forms or the LPO forms. Those are the standard forms developed by the State Bar Association, and those are available on the bar's website, actually. And so you can pull up those documents yourself to review them. And if you are varying from those forms, that is when the attorney review becomes extremely important. So let's kind of go over, when do we have to have an attorney involved, and when should we have an attorney involved, right? So if you're just using the standard LPO forms, there's not going to be edits to those forms. It's actually discretionary on whether the buyer and seller have to have an attorney involved. So what this says is, of course, they're advised to seek counsel, and to be honest, particularly for a seller, they probably want to talk to an attorney to make sure that they understand, you know, $500,000, $600,000 is a lot of money to loan. And so they probably want to talk to an attorney, but they don't technically have to. If, you know, the way it's written is essentially the documents are approved unless a party gives notice of disapproval within 5 days, that they don't like these forms, or that they have been advised that this isn't a good deal. Where an attorney is required is if they are agreeing to terms that are different than what's in the addendum. So, you know, as they're negotiating later on, maybe they decide to change the interest rate or to change the payment terms, or if they are making modifications to these limited practice forms. So there are plenty of my clients where they want to change those standard terms. And if you're going to be making a change, veering from those standard forms, then this is where it actually requires approval from the attorney. And so that is really the distinction of when you have to have an attorney and when you can choose if you're going to have an attorney review. So are you okay with the standard documents as is, or do you want to be able to make edits to those documents? I think I had pulled up, this is really the standard form that the LPOs use, right? That say who's making the loan, who's borrowing the loan, how much is it, what is the interest, and then there's kind of these select boxes that mirror, if we go back to that seller financing, they mirror, well, what are the terms that we're agreeing to here? And this gets really into the specifics of what's the down payment going to be? What's the interest rate going to be? Are there installment payments? Are there principal and interest payments, interest only? When are the payments due? Is the note going to be secured? And so when you come and look, it's I think important for an agent to be familiar with what does a promissory note look like? What does a loan document look like? What is it that the client, the seller, the buyer, whoever your client is going to be signing? And you know, sometimes people do really weird things with installment payments, and this gets kind of scratched. So that's a change to the form, which would then, under that financing addendum, require the buyer and seller to have attorneys sign off on those changes. You know,
so this is like a standard. So this isn't a form you made. This is just a form that anyone can find on the bar website.
Yeah, and I can give the link to the bar website's form. Here, I'll put that in the chat as well. And this is what escrow agents use. This is what they're legally allowed to use. They're not allowed to really make changes because they're not attorneys. And so you can see here where it says we're using the current version of the limited practice board forms. And if you go on that website I just put, and you look for form, it's 28A, but it's called promissory note. You can download it in Word or PDF. The other form that typically will go with this is the deed of trust, which we'll get into a little bit. But that's the actual lien on the property that secures the loan. And those are the two main forms that get used in seller financing. And so if your client is going to want to veer away from this form or make changes to this form, that is when an attorney will have to be involved for each of the parties. If the parties are fine with the form as is, then having an attorney is discretionary, right? Or they can seek counsel. We do this a lot. Clients will come to us, ask for advice. We'll explain the form to them. We don't actually make changes, and so we don't have to have that formal agreement, you know, or consent for them to sign it. They just want to understand, well, what does this mean? What does that mean? And you know, it's a pretty well used form. It's pretty standard, but you know, what the escrow agent is going to be putting in that form is what you and your clients are putting and checking here. So what is that total down payment going to be? What is the interest rate going to be? When does interest start accruing? You know, sometimes people will not have interest accrue for the first 3 months, you know, and because they don't have payments for the first few months, and we can't have a negative amortization. So we kind of push everything off a few months. You know, what date they're going to pay. And then this is really important. And I will say, by and large, in almost any instance, if you are assisting the seller of a property, you're going to want to tell them that they want the note secured. Because without a deed of trust, if the seller fails to, or if the buyer fails to make payments, they do not have the right to go through a non-judicial foreclosure. So a deed of trust is really important because it gives that seller the security in the property. And so, you know, most of the time the seller is going to want the first position deed of trust. Sometimes and I do have this, where a buyer will be taking out a loan from BECU, but they couldn't qualify for the full amount. So the seller is providing a secondary loan for the amount that first loan couldn't cover. In that case, they're going to have to be second. The bank is never going to let the seller have that first priority loan. You know,
clarifying that one. So let's say you're doing seller financing. So let's say somebody just wants seller financing for their down payment, their 20% or something. That's where they would use this section, and they would just select the second. Would be
I mean, this section should be used on almost any seller financing transaction, right? It's very rare that a seller doesn't want to lien against the property for the loan that they're providing. Most of the time, they're going to be that first. But yes, in that scenario, Gideon, where they're providing just a loan for the down payment, or maybe like a construction loan for, fixing things up, and the borrower actually has a lender that they're working with, a bank, then that note's going to end up being in second position, right?
Awesome.
So can I ask a quick question? Because I've had 2 of these offers already, and I've turned them both down because I'm not willing to be in a second position. And I'm just wondering if you have a scenario where it is safe. I mean, they always have things built in, they say they have things built in if the first, and they're not usually working with a bank in the first, they're usually working with another private lender, another LLC. So these deals seem a little sketchy. So I just kind of want to say there's a lot of these coming out where people are offering this, but they're actually really in a second, and they're not, the other agent is not really saying that. You have to-
Yeah, I mean, that's why it's really one, right? It's got to be selected here, right? So it's really important that if your seller or you are only willing to do it in that first position, that this box is checked, because if it ends up not being in the first position, right, that terminates the deal, because that can't be met. But you're right, it can be sketchy. Right. Anytime you're in second, anytime you're not in first position, you run the risk that let's say there is a foreclosure because your loan or even the first lender's loan isn't getting paid. The way that it works in a foreclosure is the first thing that's paid are administrative expenses. We're paying the court fees, we're paying the attorney fees, we're paying the trustee fees. Then that first loan's getting paid with all of its interest, and that's at a default interest at that point, all of its principal. Then, once that first position's paid and those administrative expenses, now the second lien holder gets paid. Then the third lien holder. And then there may be other judgments, right? So they may be in credit card debt and they got sued. And so it's important to know that if you're not going to be in first position, you run that risk that all of the proceeds of a foreclosure get eaten up. The other issue is that if you're the second in position and you need to foreclose, you're essentially also providing notice to that primary lender that you're foreclosing. And again, that primary lender still has to get paid off before you see anything. So anytime you're not first in position, and even if you are first in position, you want to make sure that there's enough equity in the property for where you're at, so that in the worst case scenario, you're going to get paid in full. You're going to recoup your losses. So you're right to be wary about being in a second position. And it needs to be clear, you know, that, and really the buyer and the buyer's agent should be clear that this won't be a first position loan that we're asking for. And they should, if that's the case, they should be selecting this, and that should be something you look at and tell your client, hey, you're not going to be in first position.
Awesome.
Yeah.
So Julie, I want to get into the meat and potatoes of all these terms, and
Yeah.
we've got about 18 minutes left, so maybe wrap it through them. But before we get too far in, I want to just go back to that first page, and and so this 5-day attorney review, just to clarify, because we're putting on our agent hats here. Does this mean that this offer, this mutual contract, is actually people can rescind within 5 days? So like anytime you accept a seller financing offer, or you make a seller financing offer, it's like you have a built-in just get out card.
Yeah, essentially. Yeah. Again, it's conditioned upon review and approval of counsel for buyer and seller. So what they can do in that 5-day period is come back and say, my attorney is advising me this is bad, and I'm terminating, right? So it's the 5 days after mutual acceptance.
Do you have to actually contact an attorney? I mean, if you just get cold feet, can you just say you're backing out?
You know, here I think then you get into, was the termination done in good faith or not? You know, here it doesn't specifically say that that it has to be an attorney's disapproval, but that's essentially what this is for. That would be something that if the parties were going to fight about, that I don't think that there's really a clear answer. I think it could be said that, well, that was done in bad faith. You never talked to an attorney. This contingency is supposed to be if an attorney disapproves it. You didn't have an attorney disapprove it. You just wanted to get out of the contract. You know, in reality, it just says if they give written notice of disapproval, that they can back out, right? Versus here, the sale can't move forward unless there's approval by their counsel. you would think, right, that here the disapproval would need to be from their attorney, but you know, as a lot of agents know, when people start getting in fights over earnest money or people backing out, it's sometimes it's not worth the fight.
I
Yeah.
have a related question here with the earnest money. Should it be deposited before those 5 days for attorney review, or can it be done after attorney review?
So the earnest money is going to be based on your main contract, your main purchase and sale. And so if your purchase and sale says earnest money has to be deposited within 2 days, it has to be deposited within 2 days. What you can do, you know, as the agent, and that's a really smart way of thinking, is to say earnest money will be deposited after 5 days.
5 days.
But
Makes
we
sense.
know that everyone's on, or after attorney approval is given, so that we aren't stuck with money in escrow that we're now fighting over when we think somebody's backed out in a non-good faith way.
Sounds good. Thank you. Thanks, Julie.
No, but that's actually a great point to bring up.
So
Yeah.
maybe let's spend like sorry to kind of hijack it, but maybe like over the next 10 minutes we try to get through kind of just a quick note on everything, and then we can
Yeah.
do the questions we have. And this is, you know, as the form says, you need to have an attorney. So this form is so complicated. So you know, we'll try to kind of organize some of the questions people have and maybe shoot them over to Julie afterwards. But if you use this form, you're going to need an attorney. So, you know, be sure to hire Julie at that point also.
Thanks, Kitty. Yeah. So, you know, again, this portion of things is really coming into, again, I would advise, particularly if you have the seller as your client, that there is a deed of trust. And most of my clients want a due on sale clause. And what is a due on sale clause? A due on sale clause says that if you transfer or sell the property, you can only do so if you pay me in full. So that is, you know, otherwise you could have a situation where you have a loan on a property, that person sells it to somebody else, they're still liable on the loan, but now you have someone else owning the property that you didn't agree to sell the property to, right? Every single bank that you deal with, every lender that you deal with, traditional lender, has a due on sale clause that says if you transfer the property or sell it, you can't do that without paying me off first, right? And there's very few scenarios where I wouldn't advise a client to have a due on sale clause. The due date is just, when is that loan going to be due? Like Gideon said, it could be in 7 years, or it could be, some people are willing to do a 30-year loan. Most individuals don't want to hold a 30-year loan. They're usually willing to hold it for 5 to 10 years. But that's the date that we agree, hey, this loan's got to be paid off. Default interest.
So the due date, so sorry, can you scroll up a bit to that first section on this page?
Yeah.
So the payments to seller, how did those relate to the due date? Because I think a lot of us think about, okay, you know, we're amortizing this over 30 years, but it's going to balloon in 3 years. So like, how do we actually write that all down?
Yeah. So, I mean, here we're saying, and this is what will naturally occur, is that if you're saying we're doing installment payments of $1,000 a month, and we're paying them on the first of each month, that's just going to happen, right? And then it's amortized, and we have our amortization schedule that's saying how much of each payment's being allocated to principal and interest each month, right? When we then come down and say the due date is in 3 years, well, at that 3-year mark, there's still going to be a big chunk of principal and interest owed. And so that is where, when we look at that promissory note, you know, it's saying this is the due date. And that is when the balloon payment occurs, is at that due date. Now, when I'm writing documents that are not, you know, if I'm tweaking these, I specifically will write in that there's a balloon payment, or we have the amortization schedule that shows a balloon payment. But that's essentially how that's how it has to occur. If the due date occurs before the loan's paid off, the rest of the loan has to get paid off.
Okay.
Whatever the then principal and accrued interest is.
So the 30-year part of it is just based on somehow you take the interest rate that's defined up there and the amount you're paying every month, and you say, well,
yeah,
those just somehow mesh together. And so it's not really like, we're not defining 30 years anywhere. We're just saying, hey, it's 2% and we're paying $1,000 a month. So somehow you plug in a formula and you say, well, if it's 2% and $1,000 a month, that means that maybe it's a 26-year schedule or something.
right. And that's kind of between the parties to decide, is what is that amortization going to be? And when there are a lot of programs that run amortization schedules, so like you could take any program, and if you want it to be amortized over 30 years at a 6% interest rate, then you see, okay, the first payment, this is, or the first year, so that you can do a monthly schedule. I find that more beneficial, but you can see that if you're doing payments at $1,000 a month, how much each month is going to interest or principal, right? And then at the end of year 3, when the balloon payments due, you'll see the outstanding principal is $192. So that naturally is going to be the balloon payment.
Okay.
Which most likely they're financing out of at that point, but yeah. So it is important. I like to include amortization schedules with my loan documents because it makes it really clear what's being paid, how much is going to interest, how much is going to principal. Here, unfortunately, this form, it doesn't really provide for those it doesn't have, you're right, Gideon, it doesn't have a section that says, what if you're amortizing, but the due date's shorter? Right. So the way that this is drafted is that whatever the length of the loan is would be how the payments are allocated. So you'll want likely to have an addendum or an initial clause in here that will say we're amortizing the payments over X years.
Okay.
If that's the case, if there's going to be that balloon payment. So if that due date is going to be different than how long you're amortizing the payments over.
Okay.
Yeah. And Gideon, I'm happy to stay longer. I've got more time if if the agents want to stay on longer. I've got an extra half hour or so built in, so I'm happy to stay longer if people want to stay and go through more of the document too, because I know we're running up on time. We talked about kind of that usury rate that I was talking about. This is saying, hey, it's a 5% interest. It's a really great interest, but if you don't pay me on time, the interest rate gets jacked up to this. If you're in default. So here you can choose a rate per annum, which is 18% if it's not filled in, or the maximum amount allowed by law. So like right now, the maximum amount in a usury situation would be 12%. So you could put 18% in, but it may not be 18%, just depending on what's there. And then the late charge, some people like to put it's $50 anytime you're late, or some people do a percentage. Again, if you don't fill these things in, they have these defaults, what most people have tended to do. For the seller, they have, if payment's not cured or if a default's not cured within 30 days, then you can do what's called accelerate the loan, which means the whole amount's due and you can go forward with foreclosure after like a final default notice. This is 30 days. Some people change that. It depends, you know, at what point you want to be able to just call the loan due and say, I don't want this person under this loan anymore. Prepayment. What does this mean? This means that let's say you do have a 30-year loan, right? And part of that 30-year loan is that you're going to be collecting interest. If somebody decides to sell the property or pay you off 10 years into the loan, they're not going to owe you 30 years worth of interest. They're just going to owe you whatever that remaining principal is. So this is pretty common. It's standard, especially for residential properties, because the parties, no one would sell their property if they have to pay like 20 years extra of interest, right? And then no further encumbrances. This is where the seller can say, the lender can say, I'm going to give you this loan. You cannot take out any other loans against this property. Naturally, those loans that anyone would take out would be second in position to the seller. But you could just say, I don't want you to take out loans. Sometimes buyers will push back on this. They want to be able to take out a HELOC, right? They want to be able to take out a construction loan. But that's just something, if you select that, that just means that the buyer won't be able to take out any other loans. If you don't select it, they would be able to take out other loans, but they'd be secondary to your loan. So you're still kind of in that somewhat protective position. Why would somebody not want a borrower to take out more loans? Because kind of like I was talking about earlier, if you're the primary lender and then another person provides a loan and the borrower stops paying that secondary lender still has the right to foreclose, right? Subject to your loan, but and you'll get, you know, paid, but you may not like the property to be that indebted. I wasn't going to spend too much time on real estate contract. I'll tell you, real estate contracts are not very popular other than east of the mountains, kind of the eastern side of the state. And they get used more for like farmland or agricultural property. But I don't know, Gideon, if you think people...
Yeah, you know, it's something I remember this being a definition on the licensing exam, and I haven't seen it since, but can maybe just give us the 20-second definition?
Yeah, so what is a real estate contract? A real estate contract, so when we look at a promissory note and deed of trust, the seller is actually transferring title to the borrower, to the buyer. And then they're getting that loan against the property, that deed of trust against the property. With a real estate contract, the title doesn't actually transfer. The contract says, this person is buying this property from me. Here's all of the loan terms. When the loan is paid off, then that deed transferring the title gets recorded. So it's essentially more protective for the seller. It's just not very common because I'll tell you, and it gets a little troubling in experience. People die, that transfer deed never gets recorded because, you know, these loans are 20, 30 years long. And so then we're stuck in this position where we paid off the loan, but the property was never transferred. Because who remembers about that real estate contract that they signed 30 years ago? But you can see here, if there is farmland, you don't get that non-judicial foreclosure, that quicker foreclosure. So that's why real estate contracts are you really see them mostly on the east side of the mountains. So most of our buyers and sellers here in King, I know Snohomish has some farmland, but most residential real estate agents aren't dealing with real estate contracts. I wouldn't recommend them unless there was some odd reason that you wanted to use one. And then we kind of touched on this earlier, Gideon, where you were saying most of the time when we see seller financing, it's when a property is owned outright by the seller. This whole section is talking about, well, what if there is a loan on the property and the seller is selling to the buyer, but they're not paying off that loan? I really caution anybody that is doing a lot of times they call them subject to or seller wraps, because, and you can see here, this section, and I talked about due on sale clauses. Anytime we transfer title, over 90% of lenders have in their loan documents that if you sell or transfer the property, my loan is due in full. If you transfer the property without paying that loan off and your lender finds out, they can call your loan due in full and initiate foreclosure proceedings if they're not paid off. So I would really caution any agent advising their client on doing any transaction where that seller's loan is not getting paid off, to be very careful, right? One is you get the consent of the lender, right? And I'll tell you, it used to be in the past that as long as a loan was getting paid, we didn't really hear from lenders, right? They're not really checking the title. In the last year, I have seen more lenders issue acceleration notices or due on sale clause type situations because the interest rates are so much higher. The lenders know that their 3% loan can easily now be converted to a 7% loan. And why wouldn't they want to do that? So, this is one of those situations where, and if you're coming down to Section 3, I'm going to tell you proceed with caution, and you're going to want to tell your clients proceed with caution. What is a seller wrap of existing loan? This is where the seller, the buyer, a seller keeps their loan. So they have a loan from Bank of America, say on the property, and they then sign a document with the buyer that says, I'm transferring title to you and you owe me for the loan that I have on the property. You're going to pay me each month, and then I'm going to turn around and I'm going to pay the lender. Again, we run across one, the issue of the due on sale clause. Two, as the buyer, you're paying the seller and you're hoping that the seller is going to turn around and pay the lender. What if they don't, right? It becomes this whole issue. I don't really, sometimes we have to get creative with financing, but again, I would really proceed with caution here. There's a lot that can go wrong. I would generally say if you don't have the lender's consent, it's probably not a great idea to go with these options. Sometimes the lender will let a buyer assume, a loan. Again, if you've got a really low interest rate loan, my guess is there's not many lenders that are going to let the buyer assume a low interest rate loan. So again, I see people do it all the time. There are some escrow agencies that will do subject to or do seller wraps of existing loans. There's not that many, and that's because it can be risky, because those traditional lenders can call the loan due if they find out that the property's been transferred without their consent.
I think a lot of people are still going to want to do this just because it's this term is like, really in vogue right now. People are always talking about subject to, and you see all sorts of meetups where they have a subject to speaker. So, how would they go about protecting and making sure that the seller is actually paying their loan? I know further down in the contract, there's a whole part about using like a loan payment processor company.
Yeah.
Would that kind of absolve that risk, or?
Yeah, I mean, so there's a couple things. If you are gonna do something like a subject to or a seller wrap, it would be more ideal to, and you can see it here, that the buyer has the right to remedy the default. So yeah, can it be written that the buyer can pay directly to the mortgage company, or the seller, you know, and then the seller can turn around and pay? It's, in this case, the buyer's at risk of losing the property, right? And maybe they've paid a good chunk of cash to the seller, and now they're taking the property subject to this loan. It may be more advantageous for the buyer to be able to make those payments directly to the mortgage. Here we talk about using a collections account. There are a few agencies that essentially will collect payment, and forward that payment to where it needs to go. And that is, you know, another option that you can say, we're going to use this third party. They're going to be the person keeping track of payments, making sure payments need to go where they go. And that's not a bad idea. You know, those collection account agencies charge, you know, but I don't think the charges are prohibitive. I think they're less than $100 a month in most cases. And there may be an initial setup fee. So it's not a bad idea. Not a bad idea to do that if you're doing something subject to, you know. And then the problem with those subject tos is we have differing seller and buyer interests, right? The seller may want the payments directly because they want to make sure the loan's getting paid, but that's the same reason the buyer may want to pay the lender directly. And that just kind of becomes a battle of, you know, who wants the sale to happen more, who's willing to concede on that point.
And can we make it so that, like, the seller has to use a payment? Like, can the buyer and the seller use the same processing company, or was that going to
Yeah, so it would be one company. Yep. So anytime you're using like in a collection account or a collection agency for that, both seller and buyer are signing the contract with that agency, and giving the instructions to the agency of how the payments are going to be collected and where they're distributed. You know, and especially with that, and just in general, when you're doing seller financing, are the payments including taxes and insurance? Some people, you know, like most people that have a loan, when they're paying their mortgage, it's including the property insurance or the property taxes, right? A lot of times the lender takes care of that. In seller financing, sometimes people say, I don't want to be in charge of paying the taxes and insurance. You do that on your own. You just pay me the loan amount. So that's one of those things that's optional, you know, as well, is that who's going to be in charge of paying the taxes and the insurance? And does a individual seller want to be in charge of that, or do they want to trust the borrower to do that on their own? As a seller, as somebody who's going to be making a loan, it's probably a good idea to vet your borrower, right? As all of us, all agents know, when your clients are getting loans, they have to qualify for the financing. As a seller, you're providing seller financing, it's still financing. It's not a bad idea, and it's probably recommended that you essentially vet that borrower just like a bank would. What's their credit score? What's their income tax? Can they afford these payments? Have they defaulted on other loans? Because if you get somebody that has been foreclosed on 3 times, you may say, well, I'm not going to lend to this person. I'll tell you, foreclosure is not fun. It's a long process.
That's a statement right there.
Yeah, you know, so yeah, the great thing about having a deed of trust is that if the person stops paying you, you can foreclose, you're going to get your money. Well, that's assuming that the market hasn't tanked. And you're also building in 6 months to a year before you go through that foreclosure process, all the while where you're not getting paid. So making sure that the person you're lending $500,000 to and giving the title to your property is qualified isn't a bad idea. But again, it's optional. Is your client going to check that box or not? Of course, the borrower doesn't want to check that box, but the seller probably does. And then title insurance. Most agents are also going to be aware that if you take out a loan, that your client takes out a loan, that the lender, BECU, they're going to force you to buy title insurance that covers their interest. And so when we don't have loans involved, people can skip buying title insurance, and a lot of people do. But if you're the lender, now you're the seller, you're the lender, you may want to have that title insurance just like a typical lender would. Some of it depends, you know, what comes up on the title report, how sure you have title, but that's also an optional clause, right? There doesn't have to be lender's title insurance. So we got to the end of the form. I think there were a couple questions in the chat.
Yes, yes. We've had a few folks leave, so I assume everyone who's still here, you know, might have some questions. So, you know, either feel free to throw them in the chat and I'll jump in, or feel free to unmute yourself at this point and ask the question. I'd say, you know, feel free to ask a clarifying question afterwards, but just be respectful of other people who might want to jump in with their questions too before we have to leave.
Yeah. And there was a couple in the chat. You know, I think the one says, or there's just a comment, banks may not manage the late fees. It's a great idea as a seller to spell out exactly what you're expecting. And the seller may need to be ready to watch and collect the fees themselves. I'm currently in a disagreement with the bank that's managing escrow for me. Yes, that the late fees, I actually have a case right now where there's, you know, when does something become late? When is the late fee collected? A lot of times people won't collect late fees, and then like at the very end, when it's time for a payoff because the property's being sold, there'll be a payoff statement that will then include all of those late fees. If you are the seller, really both seller and buyer, you want to be really clear when is it late and what is that fee and when is that fee due. So that's a really good point. And then there was another question, a lender will allow for a second to close at the same time. I think that's probably asking like a second mortgage.
Yeah, you were talking about the example with BCU where these, you know, if you don't have the down payment and the seller does the seller finance on the down payment, and then you get the, you know, you have BCU cover for the mortgage. I've heard that most lenders doing that are not gonna, you know, be closing with a second lien position like that. I don't know if I'm wrong, it's gonna be interesting. I just haven't heard that be the case.
Yeah, no, that's exactly right. I will say generally banks, traditional lenders, they're not going to want to be in second position. So in a case where there's traditional financing and then there's going to be seller financing, the seller needs to be prepared that they're likely to be the second.
Will the banks close with the seller being the second, even if they're in first? Or
some banks,
okay.
Otherwise, what will happen is the closing will happen and then the deed of trust for the seller will get recorded after the fact. Most banks don't have, they allow further encumbrances, but it's bank by bank and it's loan by loan. So sometimes they'll allow it, sometimes they won't, but generally with traditional loans, you're allowed to take out second mortgages, right? Or encumber your property. Sometimes if the bank's being, you know, finicky, the recording of that second deed of trust just occurs a little bit later, but it's still there. but I've seen banks close, just so long. Sometimes the banks will have a separate document that the seller signs that specifically says that they are subordinate and they agree to be subordinate to that primary loan. So sometimes there may be just like an extra document that they want signed.
Yeah, so I've seen these come to me as two separate transactions where they record one and the second one. But my question to you, Julie, is like, is there, sort of begs the question, like, you know, is there, is it, what would you tell a client to, you know, what is the best protection you can have being in second? Because I mean, it's not the desirable position, but if somebody has to choose between selling or not selling, what are the things that you would recommend to a client that you could put in? I mean, I've seen some, like, you know, some wording that, like, you know, could, like, you know, transfer the property back over. I don't know. I don't have my offer in front of me, so I can't really see what it said, but I mean, what do you
Yeah, I
think,
mean,
Lola? What's the best you can do?
yeah,
Being in
second
second.
positions, no, you're right. Second position's hard. Because it is, you know, like in that example that you were saying, like, oh, well, if you can't pay, you transfer the property to me. Well, that actually triggers the due on sale clause that the primary lender has, right?
Right.
So is that second position seller in the position to also pay off that loan? Maybe.
Yeah, that's where you get stuck. It's like, if you want your money now, you got to pay the first.
Yeah.
You know, and
So it
you
is.
don't have
It's
visibility into what they owe or what they borrowed sometimes. So
right, right. And so it is one of those things where, again, when we come down to one, doing that review of the buyer's finances, and part of that is, you know, if they are taking out a primary loan, that you're going to be subordinate to, knowing the terms of that loan, right? And what's that situation versus, yeah, what is the buyer's income, right? Can the buyer afford that payment and your payment? There's not that much you can do as the second in position to get added security. Sometimes I'll have clients that will put a loan on a secondary property of the buyer. So maybe the buyer has a second property and they're willing to let you establish the lien on that property. That you may end up being second in position on that property as well, but you can have, you know, you can have your loan secured by more than one property.
oh, that's genius. I think you just gave me an opening. If, because of these LLCs, they've got other properties, I could just, yeah, I'll take a first on one of your other properties.
Yeah, or even a second, but if you're, say, second on a couple properties, that gives you a little bit leeway that if things go really wrong with one property, at least you're still secured on this
On the
property.
second one, yeah.
Now, with LLCs, one of the things I will always advise the lender is to get personal guarantees from the LLC members. Most banks require that, right? And there's a reason, because if the LLC goes defunct, you want to be able to go after those individuals' assets as well to recoup. Let's, you know, again, in the event of a foreclosure in current markets, you're probably going to get paid your loan back. But if we have like an 08 happen where property values sink, there can be underwater mortgages. And so if you have that personal guarantee against those LLC members, you can go after their personal assets for any deficiency. And it gives them more skin in the game, right? Their person. Now that is a back and forth. The buyer that's an LLC may not want to, really may not want to give the personal guarantee, but that's going to give the seller much more protection. Yeah. I don't know if there's any other questions. I'll put my email in the chat. And I know Gideon has my email too. But what I'd say is, if you do have other questions, you can shoot me an email. You can, you know, share it with Gideon. And I'm happy to provide, again, I think that DFI website I sent's a really good thing to take a look at in regards to when you can make a loan, when you can't. But in general, if you are doing seller financing to somebody and it's going to be their residence, making sure that those, you're following those rules, you're getting those waivers. If it's not their primary residence, you get a little bit more leeway.
All right, well, if you have any other questions, now is your chance, guys. Thank you, Julie. You've been super generous with your time going over. This is such a complicated form. Remember, guys, you still need a lawyer when you're doing these transactions. So give Dimension Law a call if you're going to go through with one of these or you're using in one of them. And yeah, we'll have this recording out so people can watch this again and again and kind of get it all in their head. And yeah, any other questions, guys?
Good. Well, thanks for having me, Gideon. And yeah, it is a complicated form, and the more straightforward situations you'll probably be able to get through, but anytime there's those added complications, it's a good idea to really have your client talk through it with an attorney and make sure that nothing really wonkies. But most of my agents are pretty smart and have already pointed out today kind of those red flags to look for. When is it going to be too complicated of a situation?
All right. Thank you, Julie. We'll see you guys later. Talk to you later. Bye, Julie. Bye, everyone.
Bye.